Above the Law, The Engineering Arc. This book is the first of 3 volumes examining Canada's justice system through the lens of engineering. Each volume explores a different stage of design. Book 1. Engineered from Legacy. Canada's justice system did not evolve neutrally. It inherited doctrines from monarchic England, sovereign immunity, prosecutorial privilege, and discretionary impunity, and embedded them into Canadian law. These legacies form the architecture of a culture where the Crown often places itself above the rules meant to restrain it. Book 2. Engineered for Impunity. The Crown did not simply inherit structural advantages, it codified them into statutory backdoors and redundant safeguards against accountability. From discretionary stays to secrecy clauses, the system has been actively engineered to protect insiders and to frustrate those who challenge them. This is justice not as a shield for the people, but as armor for the state. Book 3. Engineered for Integrity. If law can be engineered for impunity, it can also be re-engineered for integrity. The final volume proposes reforms grounded in systems design and engineering doctrine, fail-safe rather than fail-closed, transparency rather than secrecy, accountability rather than privilege. Together, these volumes trace an arc, from legacy to impunity to integrity. What follows in this first book is the starting point, the culture we inherited, and the ways it conditions actors in Canada's justice system to ignore the rules they claim to uphold. Canada's justice system did not begin as a democratic experiment. It began as an extension of empire, a legal operating system written for a monarchy, not a republic. Spoiler alert, Canada is not a republic. It is still a monarchy, of which the Crown regularly reminds us. We inherited the code almost verbatim. Sovereign immunity, prosecutorial discretion, deference to authority. These are not democratic features. They are royal permissions that survived the transition from colony to country. In engineering language, they are legacy code, old subroutines copied into a new program without testing whether they still work. The syntax has changed. Your Majesty became Your Honor. The King's Attorney became Crown Counsel. But the underlying logic remains. The state is above the citizen. We never audited this architecture for security. We just assumed it was safe because it was old, and therefore respectable. That assumption is Canada's first design flaw. Over time, these inherited privileges didn't just persist. They were optimized. We built new layers of insulation around the Crown. Where there were once customs, there are now statutes. Where there was once deference, there is now doctrine. Section 579 of the Criminal Code allows the Attorney General to halt any prosecution at any stage. That's not accountability, it's a kill switch. When prosecutors rely on policy discretion to explain their decisions, they are invoking authority without transparency, a black box with no audit trail. And when oversight bodies dismiss citizen complaints as frivolous and vexatious, without reasons, that's not oversight. It's error suppression. In software terms, this is what we call a fail-closed system. When something goes wrong, the system shuts down, hides its logs, and rejects further input. It prevents embarrassment, but it also prevents correction. The justice system behaves the same way. Challenge it, and it locks up. Request disclosure, and it redacts. Demand accountability, and it recites doctrine. A culture that began as monarchic privilege has evolved into bureaucratic impunity. Every profession has an ethical core. In medicine, the rule is do no harm. In engineering, it's protect the public. In law, it should be uphold justice. But in the Crown's culture, justice often means protecting the institution itself. Prosecutors are trained to win, not to seek truth. Judges are trained to guard their independence, not to invite scrutiny. And citizens are trained, by exhaustion, to stop believing they can make the system obey its own laws. When Crown Counsel violate their own conflict of interest policies, there are no consequences. When internal memoranda contradict statutory duty, the bureaucracy sides with itself. And when ordinary Canadians try to invoke Section 504, the right to lay an information before a justice, The Crown quietly overrides it, or simply refuses to process it. Note, while the Crown thought they could quietly override my private information, they miscalculated and opened a can of worms, or a can of centipedes, as I like to say. We are told this is prosecutorial discretion. But discretion without accountability is not justice. It is arbitrary power. Inside the system, people learn to survive by ignoring the rules that slow them down. Rules become ceremonial. They are quoted for legitimacy, not followed for integrity. And so we hear the same phrases repeated like a sacred chant. The rule of law, judicial independence, access to justice. But repetition is not proof. It is ritual. The justice system performs faith in itself. It does not measure performance against the truth. Why look at law through the lens of engineering? Because engineers are accountable for failure. When a bridge collapses, no one can hide behind doctrine. We trace the load path, we find the weak joint, we fix the design. Personal note: a friend of mine, a professional engineer who runs a successful firm, tells me that a significant portion of her company's resources goes into litigation. She says it has become common for clients to use legal action or the threat of it as a way to reduce project costs or negotiate settlements. In her experience, this is routine in the engineering business, a cost of doing business that has little to do with merit and everything to do with leverage. Still, while litigation can be abused, it has the purpose of holding engineers accountable. Canadian common law, a system of law enacted by judges rather than Parliament, takes the opposite approach, making litigation against prosecutors nearly impossible. Law, by contrast, treats failure as taboo. When there is a wrongful conviction, it becomes the system's highest priority because it is political nitroglycerin, volatile, public, and impossible to ignore. But anything less than that, the near misses, the suppressed evidence, the quiet abuses of discretion tend to be swept under the rug. It is fair to say the system only performs genuine failure analysis when the explosion has already occurred. As Robert Frater's own writings on Crown ethics reveal, there are moments when the system does respond and reflect, but usually only in the wake of combustible, high-profile cases. Imagine if the justice system adopted the same standards engineers live by: version control for legislation to track changes and prevent unintended consequences, unit testing for new statutes to ensure consistency with the Charter before they're enacted, independent verification and validation, not by insiders but by the public they serve. Engineering teaches us the concept of root cause analysis. You don't blame the operator until you've audited the design. Yet our justice institutions do the opposite. They blame the individual and protect the architecture. Precedent, not performance, is the governing metric. And precedent is just another way of saying we've always done it this way. But tradition is not reliability. Verification is. If law can be engineered for impunity, it can be re-engineered for integrity. That begins with design principles we already understand. Fail-safe, not fail-closed. Transparency, not secrecy. Distributed accountability, not hierarchical privilege. A justice system built for integrity would include civilian charge approval panels, replacing the Crown's monopoly on prosecution decisions. It would log every discretionary decision in an auditable database, not a private notebook. It would make oversight independent, not just in name, but in power. And it would measure success not by how many cases are closed, but by how many injustices are corrected. In the United States, there is at least a tradition of public participation through the grand jury, where citizens weigh in on indictments. But even there, the saying goes that a determined prosecutor can get a grand jury to indict a ham sandwich. Political note: south of the border, the Trump administration has invited a record number of grand jury decisions not to indict. This evidences that grand juries and civilian charge approval panels can be engineered to work as required. In Canada, we have no such mechanism at all. The public has no formal seat at the table when it comes to deciding whether charges should proceed. That absence of civic participation leaves immense power in the hands of the Crown alone. If Canada is to do better, it must design systems where the people are not spectators of justice, but participants in it. These are not utopian ideas. They are engineering basics applied to governance, redundancy, verification, and feedback. The Crown's current architecture is what engineers would call brittle, resistant to small perturbations, but catastrophic when stress exceeds tolerance. Integrity requires flexibility, the ability to self-correct before collapse. The purpose of this trilogy is not to destroy the system. It is to debug it, to treat law not as sacred scripture, but as code, human, fallible, and improvable. The engineering arc begins with legacy, exposes impunity, and ends with integrity. It is a journey from inherited design to intentional redesign, from defending the system to defending the people it serves.
The bitterness of poor quality remains long after the sweetness of low price is forgotten. Benjamin Franklin. It is not enough that justice be done. It must also be seen to be done. Lord Hewart, R.V. Sussex Justices, 1924. We must build the justice we wish to inherit. The author.
So, where do we begin? With an audit. Every great engineering project begins by mapping the existing architecture, seeing what's connected to what works, and what quietly fails. Only then can we build a justice system that deserves its name. Because in the end, the rule of law means nothing if those who enforce it believe they are above it. This is Above the Law, the engineering arc.